Imagine you're stopped by law enforcement. Maybe you were doing something wrong, maybe not. At this point, when you are in the custody of law enforcement, whose safety matters more, yours or that of the officer? In the 2017 Fourth Circuit case, United States versus Robinson, while not specifically put this way, the question still came up. Does officer safety trump your right against unreasonable searches and seizures and even against your own safety? So we'll discuss that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, rise, and generation be free. Glad you could join me today. This is an interesting story. It's an interesting case. I've been looking a lot at our rights compared to those of law enforcement. So here's another example of the courts and by extension the government, well, putting the thumb on the scale towards law enforcement over the U.S. citizen. Let me get into the details of this case. I'll talk more about this. You can find all the links and all my resource material at the website, constitutionstudy.com, which I'll talk more about that site at the end of the episode. But for now, let's talk about this case, United States versus Robinson. To understand the decision in this case, we have to start where we always start, at the beginning. After receiving a tip that a man in a parking lot, well known for drug trafficking, had just loaded a firearm and then concealed it in his pocket before getting into a car as a passenger. Ranson, West Virginia police stopped the car after observing that its occupants were not wearing seatbelts. Reasonably believing that the car's passenger, Shaquille Robinson, was armed, the police frisked him and uncovered the firearm, leading to his arrest for the possession of a firearm by a felon. After receiving a tip, it appears that law enforcement may have been looking for an excuse to search Shaquille Robinson, and they found one when he drove off without his seatbelt on. Now, using the anonymous tip about Mr. Robinson being armed as a pretext, the police frisked him and uncovered a firearm. Now, since Mr. Robinson was a felon, they arrested him for exercising his Second Amendment right after he had lost it for his felony conviction. Now, was the frisk legal? Did police violate Mr. Robinson's right to be secure from unreasonable searches? Mr. Robinson thought so. During his prosecution, Robinson filed a motion to suppress the evidence recovered as a result of the frisk, contending that the frisk violated his Fourth Amendment rights. The officers, he argued, had no articulable facts demonstrating that he was dangerous since, as far as the officers knew, the state could have issued him a permit to carry a concealed firearm. Now, after the district court denied the motion to suppress, Robertson pleaded guilty to the illegal possession of a firearm, reserving the right to appeal the denial of his motion to suppress. Now, Mr. Robinson has a very interesting point. Why should someone being in possession of a firearm lead to an assumption of dangerousness? After all, for all the officer knew, Mr. Robinson could have been a legal concealed carrier. He might even have had a carry permit. How does that establish reasonable suspicion that a crime was being committed? When that didn't work at trial, Mr. Robinson tried again on appeal. On appeal, Robertson contends again that the information that police received from the tip describes seemingly innocent conduct and that his conduct at the time of the traffic stop also provided no basis for officers to reach the conclusion that he was dangerous. He argues under the logic of the district court, in any state where carrying a firearm is perfectly legal, every citizen could be dangerous and subject to a Terry frisk and pat-down. Mr. Robinson's argument on appeal gets even better. None of his conduct would lead a reasonable person to believe Mr. Robinson was dangerous unless you assume everyone with a gun is automatically a danger to society. And if everyone who legally carries a firearm is automatically subject to a Terry stop from the case Terry versus Ohio, then merely exercising your right protected under the Second Amendment could be considered reasonable cause for a stop and frisk. There's another point that I find important, but didn't see in the court opinion. The tip was anonymous. Now, under the Sixth Amendment, you have a right to confront your accuser. It reads, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. If the reasonable assumption that the police used to search Mr. Robinson was based on an anonymous tip, how can he confront his accuser? If so, Mr. Robinson cannot confront the person who accused him of carrying a loaded weapon in court. Now, how can that be used for reasonable suspicion? After all, isn't an anonymous tip hearsay? For all the court may know, the accuser has a personal interest in seeing Mr. Robinson harassed, regardless of his guilt. We reject Robinson's argument and affirm, concluding that an officer who makes a lawful traffic stop and who has a reasonable suspicion that one of the automobile's occupants is armed may frisk that individual for the officer's protection and the safety of everyone on the scene. If the reasonable suspicion of the possession of a firearm is sufficient for an officer to frisk a suspect, what about the civilian? After all, there is more than a reasonable suspicion that the law enforcement officer is armed. Does that give cause for the civilian to frisk the officer for his or her safety? If only one party is armed, then only one party is a threat to the safety of everyone. The court goes on to say, the Fourth Amendment does not require police officers to take unnecessary risks in the performance of their duties. Well, the Fourth Amendment says no such thing. I agree that police officers should not have to take unreasonable risks in the performance of their duties, but those duties include following the supreme law of the land. That is why their oath of office requires they swear or affirm to support the Constitution of the United States. Continuing, it is also inconsequential that the passenger may have had a permit to carry the concealed firearm. The danger justifying a protective frisk arises from the combination of a forced police encounter and the presence of a weapon, not from any illegality of the weapon's possession. Which gets to the root of the problem. If the danger comes from the presence of a weapon during a forced police encounter, regardless of whether or not it's illegal, why does it matter which party holds the firearm? If police were as pure as the wind-driven snow, well, then it would be reasonable for the threat to be one-sided. Then again, that would mitigate the need for police to have internal affairs divisions and for other law enforcement entities to have inspectors general. Now, while I'm sure the vast majority of law enforcement officers are just trying to do their job, there's plenty of evidence that some of those same officers have abused their positions. Not to mention that some of those encounters have led to the assault and battery of the civilian, all while the civilian is defenseless before a government official. Isn't that why we have a Second Amendment? To make sure we the people aren't defenseless against a potentially hostile government? Now, when Mr. Robinson was pulled over, the actions of the officer bring even more questions to the case. Yes, Mr. Robinson was a felon, but did the officer know that at the time? The tip only identified a black male in a bluish-green Toyota Camry, loaded a firearm, and concealed it in his pocket. Yes, this black male was leaving a high-crime area, which to me may justify the desire to be armed. Yet look at how the officer treated what should have been a routine traffic stop. After calling in the stop, Officer Hudson approached the driver's side of the vehicle with his weapon drawn but carried below his waist and asked the driver for her license, registration, and proof of insurance. He also asked the male passenger, the defendant Robinson, for his identification, but quickly realized that doing so was probably not a good idea because this guy might have a gun and I'm asking him to get into his pocket to get his ID. Instead, Officer Hudson asked Robinson to step out of the vehicle. Now, I am not an attorney, and I'm not familiar with West Virginia law, but is a passenger in a vehicle who is not wearing a seatbelt issued a citation, or just the driver? Now, if not, what reasonable suspicion does Officer Hudson have that Mr. Robinson has committed a crime, is committing a crime, or is about to commit a crime? That is the requirement for a Terry stop and search. The only thing the officer knows is that the passenger is likely armed, that is, assuming this is the vehicle reported by the tipster. Now, based on this, Officer Hudson approached the vehicle with his weapon drawn, giving those in the vehicle reasonable fear that their life is in imminent danger. I believe that is a trigger in all 50 states for a person to use lethal force to defend themselves. Remember, those in the car have no idea who the officer is or what his intentions are. All they know is that an armed person in uniform is approaching and possibly that he has a drawn weapon. Look at Officer Hudson's reasoning. He asked the passenger for his ID, then realized that this was probably not a good idea. Why? Because this guy might have a gun. Now look at this from the other point of view. They know the officer has a gun. They may even be aware that he has drawn his gun. I wonder how Officer Hudson would have reacted if Mr. Robinson, knowing that he was dealing with an armed law enforcement officer, drew his weapon because he knows the officer is armed. Now, who has a more reasonable, articulable suspicion that their life might be in danger? Is it the officer who is approaching a vehicle with an unknown occupant and the knowledge that the traffic stops go bad? Or is it the passengers who have an unknown armed officer approaching and a knowledge that some officers abuse their position, something especially known to happen to black civilians? Either way, we have a potentially tense situation made worse by the presence of firearms on both sides and the escalation of Officer Hudson drawing his firearm. Then, Captain Roberts enters the picture. At this point, Captain Roberts arrived and opened the front passenger door. As Robinson was exiting the vehicle, Captain Roberts asked him if he had any weapons on him. Instead of responding verbally, Robinson gave Roberts a weird look, as he described it, or more specifically, an "oh crap" look. Robertson took the look to mean, "I don't want to lie to you, but I'm not going to tell you anything either." So Mr. Robinson exercises his right to remain silent, but Captain Roberts sees a quote-unquote weird look. Then Captain Roberts begins reading minds. There could be many reasons why Mr. Robinson would have had a weird or an "oh crap" look. He was in a vehicle stopped by law enforcement, asked for his ID, even though I'm not sure he could be cited for the offense of not wearing a seatbelt. He was asked to exit the car, then asked about weapons. That could easily bring an "oh crap" look to someone's face. Remember though, even if Mr. Robinson is armed, the police have yet to establish a reasonable suspicion that Mr. Robinson is committing a crime. Now, at this point, Captain Roberts directed Robertson to put his hands on top of the car and performed a frisk for weapons, recovering a loaded gun in the front pocket of Mr. Robinson's pants. Now, after conducting the frisk, Roberts recognized Robinson, recalled that he had previously been convicted of a felony, and arrested him. Only now, after Mr. Robertson has been targeted for an act that was most likely perfectly legal, stopped, asked for ID, asked to exit the vehicle, and frisked, does law enforcement have a reasonable suspicion that Mr. Robinson was committing a crime? Not because he was carrying a firearm, but because Captain Roberts, after conducting the frisk, recognizes Mr. Robinson as a convicted felon, which means the ID and frisk of Mr. Robinson was conducted before police had reasonable suspicion of a crime. That is, unless carrying a firearm is assumed to be a crime until proven otherwise. Now, I have a lot of concerns regarding this case. Yes, Mr. Robinson was in the act of committing a crime by being a felon in possession of a firearm, but no one other than Mr. Robinson knew that until after he was frisked. Yes, the stop was legal since the officer observed the occupants driving without their seatbelts on. The constitutionality of seatbelt laws is a question for another day. But how does a seatbelt violation become a reasonable suspicion to frisk the passenger? Yes, there was a tip that the passenger was armed, but that was an anonymous tip though, meaning there was no way that law enforcement could follow up and validate the tip without violating the rights of Mr. Robinson. And since it is legal in West Virginia to carry a loaded firearm with certain restrictions, how is a tip reasonable suspicion of a crime? Now, according to court records, Mr. Robinson was only identified as a black male, so there was no way for police to search his record and identify him as a felon, which would be necessary to reasonably lead them to believe Mr. Robinson was committing a crime of a felon in possession. I understand the bias to fight against Mr. Robertson. After all, he was found to be a felon in possession of a firearm. But do the ends justify the means? What's to prevent law enforcement from stopping you or another innocent person simply because they were observed in a perfectly legal act of loading a firearm and concealing it on their person? There are some places where I'm not allowed to carry my firearm, so I lock it in my vehicle. When I exit, I check my weapon, then put it back in its holster. Should someone observe me doing this be sufficient for me to be frisked by law enforcement, especially here in Tennessee where permitless carry is legal? Is that not being considered guilty until proven innocent? The courts may have had an easier time finding the frisk unreasonable if Mr. Robinson hadn't been a felon. Then again, hindsight is 20/20. At the time of the stop, Officer Hudson and Captain Roberts had no reasonable, articulable suspicion that Mr. Robinson was a felon or that he did not have a carry permit. So, under the precedent of Terry versus Ohio, the police had no reasonable, articulable suspicion that Mr. Robinson was committing a crime, making the frisk an unreasonable search, violating the Fourth Amendment and Mr. Robinson's rights. This violation of Mr. Robinson's rights was compounded by both the district and circuit courts who heard the case. I guess under current federal jurisprudence, the ends do justify the means, and gun owners are considered guilty until proven innocent. I know, when you find a criminal in the act of committing a crime, there's a bias to want to find them guilty. But what if it requires violating that person's rights to do so? Because if they can violate Mr. Robinson's rights because, well, they think he might be committing a crime with no actual evidence or reasonable suspicion, well, then what's to prevent them from violating your rights because, well, you could be committing a crime. In fact, based on certain studies, each and every one of us commits 3 federal felonies a day because of the laws and rules and regulations that no one can actually know. So do police have the authority to simply claim, I thought he was doing something wrong, therefore I violated his rights? No, that's what the Constitution was designed to prevent. And what's this idea of officer safety versus everyone else's safety? Again, Captain Roberts removed Mr. Robinson because of officer safety. Well, if officer safety is the concern, what about Mr. Robinson's safety? Was he not safer in the car than out? And again, without that reasonable articulable suspicion, the search was invalid. It was unconstitutional. It should be void, and the court should have found that. Now, I don't know if it was the bias of he turned out to be guilty anyway, or if it was just a bias towards law enforcement. I don't know the judges. I don't know how they think. I try not to read minds. But it's important for you to understand your rights because that's a scenario where, well, maybe you could have exercised them. Maybe you could have asked for the reasonable articulable suspicion before getting out of the vehicle. Now, a lot of police don't like you when you actually exercise your rights. They don't like it when people know how to defend their rights. But that's how we protect them, is by exercising them and defending them. That's why the Constitution Study exists, to help you know your Constitution, know your rights, and be prepared to defend and assert them. That's why I wrote the book, The Constitution Study, to help people read and study the Constitution so that they can know their rights and be prepared to defend them. It's why I do these videos. It's why I do the podcast. It's why I have my radio program. It's all about helping to educate people about what the Constitution, the supreme law of the land, actually says and how we can use it to defend and assert our rights. Now, I hope you enjoyed this episode, and I hope you want to support the work that we're doing here. There's a couple ways you can do that. One is there's this great course I found called The Miracle of America. It looks at the history of the United States from, well, before we were the United States, back from the Pilgrims through the drafting of the Constitution. It helps explain why the Declaration was written the way it was, why the Constitution is written the way it is, and why our government the federal government looks the way it does. Now, I liked it so much, I made a deal with the owners to get you a lesson absolutely free. Just go to constitutionstudy.com/1776 study guide, and you'll go to a custom landing page just for my listeners, where you can read about the course, but best of all, you can enroll for a free lesson on God's natural law, absolutely free. You get a downloadable study guide and an hour of content, either audio or video, all absolutely free. Now, if you like that and want to take the rest of the course, well, the whole thing's only $17.76. So it's really worth a try. The other thing I hope you'll do is, well, use your cell phone to support the work that we're doing here. See, Patriot Mobile is America's only Christian conservative wireless provider. They use the same towers and the same networks that the major producers do, the major carriers do, but they don't support those same organizations. It's why I joined them years ago and why I partner with them to help let you know that this service is available. Imagine walking around using your cell phone knowing that everything you spend for is being used to support organizations that defend your religious freedom, your freedom of speech, your freedom of the press, even your right to be secure from unreasonable searches. Go to patriotmobile.com/constitution, find a plan that works for you. But if you join today and use the code Constitution at checkout, you'll also get free activation. So again, go to patriotmobile.com/constitution, find a plan that works for you, and don't forget to use that code Constitution at checkout to get free activation. Regardless of all that, I hope you'll come back to the work we're doing here. I hope you come back for the next episode. I hope you'll share this episode and all the other ones that we do. Help other people know about their rights and how to defend and assert them. And then bring them along the next time you join us here for the Constitution Study.